I understood him to be saying that what he wanted me to do was drop any investigation connected to Flynn's account of his conversations with the Russians.
The president never suggested that Mr. Comey, quote, let Flynn go.
Well, returning to our top story now, and as we saw set out there, one of the questions is, who do you believe in this story? And to discuss that and some of the other issues raised, we're joined by Nick Ackerman, who is in New York City, a former assistant special Watergate prosecutor and a former federal prosecutor. And here in our studio, Jeffrey Myers, a professor of law at Dalhousie University in Halifax. And Nick, let's begin with you. Based on what you saw today from James Comey, based on your experience in law, was Comey a credible witness?
I thought he was extremely credible. And what made him so credible wasn't just that he was so detailed, but the fact that every conversation that he had with Trump was detailed in contemporaneous memoranda that were written right after the conversation. He had every reason to be concerned. He was put in a bad position. Any idea or notion that he was not credibly reporting what was being told, I think, is absolutely ridiculous. I guarantee you, unless Trump has got tapes of what was said, this is a pretty credible witness who's got contemporaneous memoranda basically created like right after the conversation. So if you're looking in terms of a credibility contest, I just don't see that there's any issue there.
And of course, Comey says if there are tapes, bring it on. He'd like to hear those tapes. Jeffrey, you practiced law for a couple of years in New York City, and you were saying this idea of somebody writing down a record immediately after a one-on-one conversation doesn't surprise you at all.
No, it doesn't. You know, I worked at a firm called Sidley Austin LLP in New York, one of the better firms in the U.S., and all of the junior associates were basically taught on the first day that, you know, when you're dealing with a client, when you're dealing with opposing counsel, under any circumstances, if something strikes you as, you know, you're not sure, it puts the hairs on the back of your neck up, and it just gives you reason to pause. What you want to do is you want to memorandize the conversation, and you want to write down everything while your memory is fresh. Why? Because later on down the road, should it become relevant for some reason or another, your recollection will not have faded in the same way, and it will be entitled to greater and more persuasive power because it was written down at the moment.
And I'd even take it one step further in the sense that look at what Comey's testimony is corroborated by. Most significantly, it's corroborated by the admissions of the president. Donald Trump admitted that when he fired Comey, what was on his mind was this Russia thing that he wanted to get rid of. This day, he admitted to the Russian ambassador in front of his staff, the ambassador's staff, that he fired Comey, who he referred to as a nutcase, to get rid of this weight of the Russian investigation on him. So you've got his own admissions, and then you've got the testimony that will ultimately come out from the two intelligence directors who did not testify about these conversations the other day, but clearly will testify in a grand jury if subpoenaed by Mueller, that the president asked each of them separately to put an end or try to put an end to this FBI investigation. So the corroboration here of what Comey said makes it even more credible.
Let's move on to another issue now, and really this may be the issue at the heart of this entire controversy and these memorandums, and that is, was the president guilty of, or did he actually obstruct justice? Let's listen to an excerpt from today's hearing.
He did not direct you to let it go.
Not in his words, no.
He did not order you to let it go.
Again, those words are not an order.
No. He said, I hope. Now, like me, you probably did hundreds of cases, maybe thousands of cases, charging people with criminal offenses. And of course, you have knowledge of the thousands of cases out there that where people have been charged. Do you know of any case where a person has been charged for obstruction of justice, or for that matter, any other criminal offense, where they said or thought they hoped for an outcome?
I don't know well enough to answer. And the reason I keep saying his words is I took it as a direction.
Right.
I mean, this is the President of the United States, with me alone, saying, I hope this. I took it as, this is what he wants me to do. Now, I didn't obey that, but that's the way I took it.
So the issue here is when the president told James Comey, according to Comey's notes and testimony, that the president hoped that Comey would drop the investigation into Michael Flynn. Is that enough for obstruction of justice? Nick Ackerman, based on the testimony today, did you see obstruction of justice?
Absolutely. Look, you don't have to actually say precise words, stop the investigation. I mean, there's been, I know of one case in the Southern District of New York where a defendant was convicted, a lawyer was convicted for advising somebody to take the Fifth Amendment. And the reason he was convicted of obstruction, according to the court, was because his intent was to keep this witness from testifying and spilling the beans on him. It all goes to his intent. The same thing here. There's no question that Donald Trump was intending to get rid of that investigation. Again, going back to the motive of why he would be doing it would be so that he could contain the Flynn matter, so that Flynn wouldn't be convicted, wouldn't be sentenced, and wouldn't ultimately be pointing the finger at the president. This, to me, is a fairly straightforward, classic obstruction of justice case. People can do things that might, under the normal circumstances, on the face of it, appear to be innocent activities. But if their intent is to obstruct, impede the investigation, as was clearly the case here, even the president admitted it himself that this was on his mind. I mean, I never had an obstruction case like this where I actually had somebody admit what was on his mind at the time he did the acts in question. This is a very unusually strong case.
Jeffrey?
Yeah, I mean, I would totally agree. I think it's interesting. You've seen some reports coming out that lawyers are being asked, additional lawyers are being asked, understandably, to come on Mr. Trump's legal defense team. And many of them from the most reputable firms are deciding not to do it and are declining the offer to act for the President of the United States. And the reason is because anybody who's observing this as a lawyer or as a legal professional, it's quite apparent that he's not listening to legal advice. And, a classic example of that was people were asking, a few days ago, why isn't Mr. Trump asserting executive privilege? That was the big question when people were asking a couple days ago. And the reason is exactly that he had blown it himself by tweeting about everything and speaking about it. And making statements which made it such that any claim of executive privilege, which would be completely laughable.
All right,
And
well,
I might add,
sorry, jump in, Nick.
Yeah, as a statement in furtherance of criminal activity is not covered by any kind of privilege. I mean, that would break the privilege right there.
So, yeah. Great talking to both of you. In fact, we have more to talk about, so stand by. We'll lots of issues raised by the testimony today, and we'll get to that after the break.